So that's preparing for the live stream, and then I'm going to go ahead and admit everyone right now. Welcome, everyone. Thank you for joining us today.
Did you want me to go ahead and get started, or do we want to wait for a few more participants?
That would be great, Sherry. Do you want to go ahead and kick us off? We could do a little screen share, and just really excited for everybody that we have joining us today. Some familiar faces, and always so thankful for everybody that's involved in the inventor community in St. Louis. Students, faculty, staff, or in residence professionals are joining us. So we're really fortunate to have Jason with us today from USPTO, and really excited to get into it, Sherry.
Okay, well, let's have at it. Guys, I just wanted to thank you for participating in this event. One of the reasons why I wanted, first of all, I'm Sherry Renee, and I am president of the Inventors Association here in St. Louis, and I'm also president of Invent Ed Network Connection. And the difference between the two is that the Inventors Association of St. Louis is a networking group for inventors to come together once a month and just kind of powwow and exchange ideas, and then speak with sometimes patent attorneys or product developers and that kind of deal, in order to further their ideas along or get certain questions answered. Whereby the Invent Ed Network Connection, we offer more. We offer the programming, the workshops. We reach out to different organizations to make sure that we are able to maximize the resources and match them with inventors like yourself and innovators, along with other more administrative, holistic type of approach. So with that said, I'm going to be operating, I won't be speaking much today. We have a lineup for you throughout the month of January, in addition to February. And I should also let you know that I'm not just the president of the different inventor organizations. I'm also an inventor, and a once frustrated inventor at that. So I know what it's like to be in your shoes and to be forced to research every aspect of the development of your particular idea or product without having any foreknowledge about your particular product or the mechanics of it for that matter. And so during my journey, what I've realized is that I spent more time in researching information than I did actually developing my product ideas. And then when I finally found out the information, my first reaction was, that's it? It could have been that simple. And it would have been that simple had I knew a guy that knew a guy that could provide me with the information that I needed to keep going, not just the intro information. And so what we found through the Inventors Association and through Invent Ed Network outreach is that all inventors, mostly all inventors, experience the same frustration. Doesn't matter what your background is, doesn't matter what your financial resources are, you still remain in the dark. And so this is an opportunity for us to shed light on the innovation process and the different things that resources that are available to you to advance your idea and just get it out of your head and onto paper and develop into a prototype, etc. But how do you do that? Where do you begin? There isn't an inventor university. There's no such thing. There's not an inventor school, and there are not really any inventor classes. So this is why we created these particular set of classes for you. And for those of you who may have had the fortune of literally and figuratively, as far as the financing to further your ideas because you're able to afford an attorney or what have you, sure, you may become patent pending, but you don't know how to commercialize your particular product. Or you have another idea and you don't have the financing that you once had. How do you get that off of the ground? Well, we aim to answer those questions for you today. So let's see here. And one of the things I wanted to help you guys to appreciate is that you are not alone in your journey anymore. For those of you who are participating today and in other sessions, know that we are here to provide you with the information that you need. And thanks to our St. Louis Dream Team, that includes the United States Patent and Trademark Office, we brought out the big guns. I mean, as an inventor, we often hear, you network in the different environments, which are really good and healthy. Sometimes you refer to the wrong guy, and then someone may say, I know a guy who knows a guy. Well, we're going to introduce you to the guy. You won't believe our lineup here today. So I hope that you are just as excited and enthusiastic about your product development or idea development, because moving forward, remember that I told you this today, you're going to end up on an accelerated path to innovation. Anything that you thought would normally take 2 to 3 years, 5 years to save up or to figure out, I'm going to tell you within about 6 months, 3 months, in some cases, in my case, I have a story to tell that's about 3 months that I went into one major event, and before I knew it, because of the networking and the research and the referrals, I was able to end up with a prototype and become patent pending. So just know that it's very viable and very realistic. So with that said, today's class is going to, it's more of an advanced class, but not absolutely. And when I say that, what I mean is that those individuals who are participating today, it's open to everyone, of course, but are participating today, they are ready. They already have something completed. It's their idea is no longer a concept. They want to, lock in the name, or they have a business or a product that's already developed. And then there are some of you who are just wanting to pack your brain with enough, fill your mental hard drives up with as much information as you can during the process. So with that said, we're going to talk about walking through the trademark application process. Because we are in trying times and during a pandemic, we realized that not everyone had, first of all, the resources that you once had, you have to use it for other things. It's no longer something that you can use or invest in extracurricular activities. So there, you have to be resourceful. And you have to do things on your own. And with that realization, we're wanting to provide you with the tools and knowledge and know-how to actually submit application material, trademarks, patents, etc., yourself. So that's another reason why we're offering this to you today. So with that said, let's walk through the trademark application process. As I mentioned, you're in good company, because this is brought to you by the Inventors Association of St. Louis, United States Patent and Trademark Office, InventEd Network Connection, and Washington University's St. Louis Scandalera Center. I normally go through what InventEd Network Connection does, but we want to go ahead and make sure that we maximize the time since we got started a little late. But basically, we are here to help you save money and actually become invented. We don't want you to just, it's not enough that you end up with a trademark. It's not enough that you end up patented. What we're wanting to do is to have a completed invention that you can actually begin selling or sell to a company. So when I talk about the big guns, I want to let you know that if some of you have probably already gone onto the USPTO website, and you've come across this particular set of videos, which are fantastic for those of you who have participated, who have viewed these particular links, you'll find that they're very informative, straightforward, clean cut, and you have all the information that you need to get started and to be empowered to do it yourself. Well, this session is going to provide you with the basic facts that are contained within those videos, and also introduce you to the TEAS electronic filing system of the United States Patent and Trademark Office, and we'll go over that more during the presentation. And you probably, when you clicked on the link, you came across Mark Trademan in the video, who's very polished, and he's very patient and informative as far as how he explains his information. But guess what? That's who you're seeing right now. That's Jason Lott here. So when I say we brought out the big guns, I don't know a guy who knows a guy. This is the guy who created these videos and is here to tell you everything you need to know about trademarking. Welcome, Jason Lott, and thank you for participating. I'll turn it over to you.
Great, thanks. Appreciate that, Sherry. All right, guys. Well, I'm going to share my screen, and so we can jump in right here. So as Sherry said, my name is Jason Lott. I'm the attorney advisor for trademark educational outreach at the United States Patent and Trademark Office. And essentially, that's a really long way of saying that it is my job to teach you about trademarks, what they are, why they're important, and for purposes of today's presentation, what are the steps that you need to take in order to actually fill out the application to register your trademark at the United States Patent and Trademark Office. So we're gonna go through a couple of things. The first thing that I want to do, though, is to make sure we're all on the same page. So I want to very quickly go through some trademark basics. There might be some of you who already know this stuff. Jason, please move on. But then there might be some of you who are newer to it, who might know a lot about the patent side of things, but not so much about the trademark stuff. So I just want to make sure we're on the same page with regard to the basics. And then we're going to talk about TEAS, which, as Sherry mentioned, is the Trademark Electronic Application System. We're going to talk through this little pre-filing checklist, which I believe Mike has put into the chat session. So you should be able to get a copy yourself. It's a PDF. And then we're going to actually walk through a form so you can actually see it. So when you apply, it won't be the first time you've seen this, crazy government form that you have to fill out. Okay. So first things first, let's talk about what is a trademark. And what I'd love to do is very quickly talk through what you're seeing on the screen right now. So Interbrand is a private company. They do valuations of trademarks. And so this is their evaluation from the last year, or it's as current as it can be anyway. And if you look at there, you can see the top 24 brands in the world, right? And one of the things I love about this slide is the fact that it really reinforces what a trademark is. So if I say BMW, what do you think of? Cars. If I say Coca-Cola, what do you think of? Soft drinks. Google, search, Nike, shoes, right? Chanel, fragrances, right? So every time you see or hear a trademark, you automatically think about the goods and services that come with that trademark. Because, just so we know, from a legal point of view, what a trademark is any word, slogan, symbol, design, or combination of these that does two things. First, it identifies the source of your goods and services, and it distinguishes them from the goods and services of another party. So think about that. BMW tells you it's a BMW car, which is different than a Mercedes-Benz car, which is different than an Audi car, which is different than a Ford, right? So every single time that trademark is telling you what it is. And if you remember back in those days when we were allowed to go to restaurants, then I think the best example is if you go inside, you sit down, the waiter comes over, says, "Can I bring you something to drink?" And you say, "Yes, I'd love a Coke." And the waiter says, "Is a Pepsi okay?" And that is a trademark in action. It is identifying the source of the goods and services. In this case, it's identifying Pepsi as the source of the soft drinks that they serve at this restaurant. And it's distinguishing them from the soft drinks of Coca-Cola, which they do not serve at that restaurant. Okay, so that's what a trademark is. It's any word, symbol, slogan, design that identifies the source of your goods and services and distinguishes them from somebody else. So how that relates to your invention that you're creating. Let's say you're coming up with a new sort of solar panel and you want to have a good brand name for that solar panel so people don't get it confused with your competitor's solar panel, which is of course a piece of junk, because you are amazing and you've created this new thing which is going to change the world. Okay, so that's what we're talking about when we're talking about trademarks. We're talking about brand names, slogans, logos, things of that nature. So let's say you've got it. You know exactly what brand name it is or what slogan or logo or design it is that you want to register with the USPTO. So you need to fill out the form. Well, one thing you should know is that you have to use the Trademark Electronic Application System to file your application. You know, back in the old days, like a year ago, you could still file on paper, but that's not the case anymore. And now everything must be done electronically. So you're going to be using our online form in order to file your application. There are a couple of rare exceptions, but for the most part, everybody's using, we're talking 99.9% of the time, you're going to be filing your application electronically. So one thing that you are going to want to do before you start that application is take a look at the TEAS pre-filing checklist. And I'm going to go through all the stuff that's on here. So if you don't have a copy of it handy, you can't get it out of the chat, or you haven't seen it yet, that's totally fine. Don't worry. You can get a PDF of it in the chat, or we'll get it sent to you afterwards so you have one. But this is a great little thing that we've put together because it's going to help you, because there are lots of things that you need to do before you even open up the form. So let's go through a couple of those things. So the first thing you're going to want to do is determine your mark type. And that is because it is really up to you what version of your trademark it is that you want to register. Now, some people get a little confused by that. They're like, well, no, I mean, like, it's my trademark, like, it's my brand. I've got like the little thing, and I've got a little curly thing. And well, okay, all of those things could be true, but you don't necessarily have to register just the thing that you use all the time. You can actually use a different version of your trademark in order to get more protection. And there are two main things, and you're going to see this in the form itself. So there are two things. The one thing is the standard character drawing. And that means that you are not claiming exclusive rights. You are claiming rights to the wording itself. Okay, not what it looks like, and not what color, or not the font or the size or any stylization, anything like that. You are claiming rights to the wording itself. And that is an incredibly broad scope of protection, because it means if you register that wording as your trademark for your goods and services, that means over the life of the trademark, you can put it in whatever color or font or style or size you want to. You can change it up. I mean, think about how the Coca-Cola trademark has changed over the years since the 1800s, right? Think about your trademark that same way. Don't you want to be able to adapt and make it more modern as you go? And you can do that if you register your mark in the standard character version. Now, there might be some reason that there's a stylization or design element that's really important to you, and I'll show you a couple of examples where, just so you have a better idea in your head. And if so, you can register that, and you would file what is known as a special form mark drawing, and that just means that your mark appears in a specialized form. Right? It might be stylized, or it might have a design. Maybe it's in color, maybe not. All those sorts of things. And if you do that, it requires a couple more steps you gotta complete in the application form. But that is going to help protect you for the mark as it appears with the various stylizations or design elements, things like that. Now, remember, if you are going to do that, you're going to have a JPEG image to attach to your application. So you're going to want to have one of those. So what I'd like to do is show you very quickly, because you're going to want to have all the stuff on your hard drive before you even start the application. Okay. So what I want to do is show you some options of examples for things that you might encounter. Okay. So let's say that your mark is T-marking. Okay. It's an example we use here at the office. And this is the standard character mark version. You don't have to have a JPEG of this, okay? I'm just doing this for an example purposes to show you, because when you fill out the form, all you got to do is type it in, and the application does everything for you with regard to what it looks like. But here, again, standard character mark, you're not claiming exclusive right to anything except for the wording itself. So you can use it in whatever style or font you want to over the life of the trademark. Now, what if for some reason T-marking, it's really important to you that you have it in a stylized font? Well, this is a special form mark. It is the stylized version of T-marking. You might have what's known as a composite mark, which is a composition, right, of a stylized mark and a design element, still a special form mark. Or it might just be a design itself. This is our T-marking character. Right. So it could be when you apply to register, you're thinking through, well, what version of my trademark is it that I want to register? What is the most important thing to me? Is it what it looks like, right? Or is it a combination of these types of things? Or is it the wording alone that I want to protect? Now, I can tell you, well, okay, let me take one step back. Even though I am an attorney, I am not allowed to give you legal advice. Okay, so what I'm about to say is not legal advice. All right, but what I can tell you is that over the almost 20 years that I've been working in trademarks, one of the things that I have seen that is invariably inventors and small business owners who don't have a whole lot of money stashed away to spend on trademarks do one of two things. When they are applying, they will either apply for their trademark in the standard character format, right? In this sort of format, or if they are applying for it, they might actually apply for it in black and white, right? Because the thing about a black and white mark is that you are not claiming exclusive right to any of the colors. So here, if you were going to apply for this mark, you would have to claim orange and blue and white and black and gray and all those sorts of things, right? And that means that your protection is only for the mark as it appears like this. But if you apply for your mark in black and white, you don't have to claim color. And that means over the life of the trademark, you can use it in whatever colors you want to. Okay, so those are the things you need to think about before you even open up the application. What version of your trademark is it that you want to register? And once you have figured that out, you're going to want to identify your goods and services. And what in the world does that mean? Well, remember how I said your mark is always tied to particular goods and services? That's right. So you need to identify in your application what goods or services or both it is that you use with your application. And we have on our website something called the ID manual. Actually, there's a really long and complicated name for it, which doesn't really matter because everybody calls it the ID manual. And what you can do is you can go through and look in our manual to see what are the types of goods and services. What's the wording that is considered acceptable? Because it's not the same thing as a patent, right? When you're filling out your patent application and you have all the different claims that you're filling out, it's not the same thing. Sometimes people get confused and they think it is, but it's actually not. For the identification of goods and services, it needs to be very precise, but it doesn't have to be super precise. You want it to be broad, but still acceptable. All right. So let's say, for example, you invented a new sort of T-shirt, and you were going to be applying to register your mark for T-shirts. But those T-shirts that you invented was actually some sort of, it has a new sort of like thing woven into it that makes the T-shirt shimmer in different colors, depending on the time of day, and that there's also rhinestones that are all over it. Okay, well, you wouldn't have to say a T-shirt woven with fabric with rhinestones, right? You wouldn't have to do that. You could instead pick a broad but accurate identification that is T-shirts, or even shirts, or even tops. Okay, so all of those three words are actually acceptable in our ID manual. So one of the things that you could do is you could go through the ID manual, look to see what's acceptable, and be like, this is what I'm doing. This is what I got, and it's a broad identification, but it's still precise enough to show exactly what you're doing. And when you're filling out the application, you will have access to the ID manual as you fill out the form. So you can search in the manual and then click, yes, insert this checked entry. And it's a nice and easy way to make sure that the wording you're putting in there is acceptable wording. Another thing you need to do is figure out your filing basis. There's a lot of stuff you got to do before you even open up the form, right? Okay, so just in terms of background, in order to register your trademark at the USPTO, you must be using it in interstate commerce. Okay, so commerce between Missouri and Kansas, or Missouri and Illinois, or Missouri and some other state, or between you and Missouri and somebody in a foreign country. Okay, so across state lines, that's interstate commerce. That is in order to register your trademark, and it's the specific reason is because of the Commerce Clause of the in the Constitution, which allows the federal government to have the trademark system that we have in place now. So you must be using your mark in interstate commerce in order to register it. All right. However, you don't have to be using it in interstate commerce in order to apply, because if you are not yet using your mark across state lines, and let's say you're only using it in St. Louis or something along those lines, well, that's okay. You can go ahead and apply to register your trademark with us. but it will not register until you amend your application to show us that you are using your mark in interstate commerce. Okay, so there are other filing bases, but those are the two most important ones, and the ones we'll take a look at today when we go through the form. So you're going to figure out, am I using it now? In which case I would file under Section 1A, use in commerce, or do I have an intent to use it within, say, a bona fide intent to use it within the next, say, 3 to 4 years, in which case you could apply under the Section 1B intent to use basis. So you'll need to figure that out, because when you apply under the Section 1A use in commerce basis, you have to show us, hey, USPTO, this is how I'm using it. And you'll have to submit a specimen that shows this is how I'm using my mark in interstate commerce. And I will show you some examples of those to help you understand a little bit more about what in the world is meant by a specimen, because it sounds pretty medical, and we don't want that, okay? We don't want any of your medical stuff, all right? So, back in the day, people actually had to send in actual things, and not just done electronically. So that's good that we're not sending any medical specimens anywhere. Okay. So the other thing you'll need to do is also choose your application form option, because there are two options that we have now. One is TEAS Plus and one is TEAS Standard. And we'll talk a little bit about that, because one of them is a cheaper price and the other one's a little bit more expensive. And I'm going to suggest that you guys use the cheaper option. Okay. And I'll talk about why that is. So those are the things I want you to think about. Go through the checklist in advance, okay? Make sure you know what version of your mark you want to register, identify your goods and services, know your filing basis, and then be thinking about which version of the form you want to use. All right, so we are going to go through and actually, let me check time here. Okay, good, doing good. All right, we're going to actually go through and see what it is like to fill out one of these applications. All right, so in order to fill out your application, you will need to go to our website, which is uspto.gov. As you can see right up here, this is our site. You will see this button up here for My USPTO. Just so you know, we're not going to see it today when I go through, just because I've already logged in and it would take too long for me to fill out stuff. So I've already logged into the My USPTO system. If you don't have an account already, you will need to create one. Right. And that's not a bad thing, right? Because we're trying to make sure that your privacy is protected and things like that. So you will create a My USPTO account, which you would then use to log into our system for filling out an application. But it also gives you a way to see everything else. I think I might still have it pulled up here. Oh, maybe you'll have to see me log in. It might have timed, I'm sure it timed me out. Cool. Oh, wait, there you go, guys. You'll get a chance to see me logging into the system. All right, so this is inside myuspto.gov. And the cool thing about it is that it allows you to look at your trademark docket as you begin to file more things. And I believe it also will give you an opportunity at some point, if it's not there already, to see any patent stuff that you have pending before the office. I'm not exactly quite sure where we are yet with regard to that on the patent side, but this is going to be, but myuspto.gov is going to be a great way for you to, make sure you have control over everything in your own portfolio. Okay, so all right, Jason, that's enough. Let's take a look at the form. All right, so you'll go to uspto.gov. What I would suggest is you go to the Find It Fast option over here. Go to trademarks. We're not going to talk about searching today. We always recommend you do a clearance search before you file. We obviously don't have time to talk about that today, but you can learn more about it on our site, or we're going to be offering a Trademark Basics bootcamp coming up, which you guys will hear about, and one of those is about searching. So that's TESS is what you use to do the searching, but we are going to focus on TEAS, the Trademark Electronic Application System, and you want to fill out one of the initial application forms. And as you can see here, remember how I said you had two options? One was a cheaper, one was a more expensive, right? So we have TEAS Plus and TEAS Standard. And as you can see here, you can, if you're like, what are the differences here, Jason? I'm not going to have a chance to talk about all of them today, but you can read about them here on the website. You can sort of go through, and we have, as Sherry mentioned, one of our T's, nuts, and bolts videos, which gives a more detailed explanation of the differences between them. And you can watch that quick video. It's 2 minutes, 3 minutes. So the one thing to think about is the fact that T's Plus, yes, it is cheaper. And so what you're having to do, though, is sort of front load your application with all the things that you will eventually have to include. Right. So in exchange for you giving us everything we need at the top, we're going to give you a little break on the price. But if you're like, I'm not sure about this, I want to take my time, you can apply T standard, but it is going to cost you an extra $100 per international class in order to do it. So because we're recommending that you use T's Plus, that's what we're going to use today. It actually, I think whatever the metrics I saw most recently is that you're 2 times more likely to get an initial approval on your application if you're using T's Plus, and you're about 2 times more likely for your application to go through without a whole lot of trouble if you're using T's Plus. So we do recommend that you use T's Plus. Okay, so here's the form itself, the sort of first page. So of course you're going to read all the instructions because that's what you do. And then you'll choose between T's Plus and T's Standard. We're going to go with T's Plus. And please note here, if you mess up your T's Plus application and you don't front load everything like you're supposed to, the examining attorney assigned to your case will let you know, and you'll have to pay an extra $100. So take the time, make sure you're filling it out properly, okay? And then you'll answer this question, is an attorney filing the application? And we get this question all the time. Jason, do I have to have a lawyer? Can I do it on my own? Well, we used to be able to say, no, you don't have to have an attorney. You can do it on your own. It's a little bit different now. If you are domiciled in the United States, so if you're filing as an individual and your primary place of residence is in the United States or its territories, or if you're a business and your principal place of business is within the United States and its territories, you do not have to have an attorney. It's only if you are domiciled outside the United States that you have to have an attorney, right? So if you live abroad and are applying for protection in the United States, yes, you'll have to have an attorney. Or if you are a business with a principal place of business outside the United States, then you have to have an attorney. For our purposes here, I'm going to just assume that we're all domiciled here in the United States. So when we're not an attorney, we'll just assume that for today. So because unless you have an attorney and you're filling it on your own, you'll probably click no and then click continue. And then this is, seems to be a pretty basic thing, but sometimes people get a little confused by it. So the owner of the mark, people sometimes are like, oh, well, I'm filling out the form. I'll just put my name in there. Not necessarily. The owner of the trademark might be different than the person filling out the form. Okay, because the owner of the trademark could be an individual. It could be you as the inventor. You got this awesome new solar panel and you got this awesome new brand name that you're going to do. So maybe you own it, or maybe you formed a business which owns the intellectual property rights to your new solar panel. And they're going to also own the rights to your trademark. So it's going to depend on who the actual owner of the trademark is, right? So if it is a business, then let's just call it T Markey LLC, right? Then you would type in T Markey LLC. You would come down here and you would click limited liability company, and you would indicate which state it is that you're in which you're organized. So we'll just go with Illinois. Okay, how about that? So and then you would proceed to go in and fill out the rest of the information down here with regard to that, like your contact address and things like that. So, but let's say we actually, you own it as an individual. We'll put in, oops, here we go. Let's just say it is John Doe is the, I'm sorry, let me do it correctly, guys. It's Doe John, okay? And John is an individual. So he would click individual, and let's see, it doesn't really matter. Let's go United States. We're just going to fill it out for John, okay? Assuming that this is John. So we'll go 1, 2, 3, and he lives at Test Avenue in Test, which is obviously a city in Illinois. And let's say his postal code is that. And then we would also want to make sure we include his phone number. Okay. and also his email address, which is test@test.com, right? And maybe if you have a website, then you'd be you'd add that as well. It's not a requirement that you put your website address in there. We often recommend it because it helps the examining attorney when they're trying to figure out what's going on with your application, or if something were to go wrong, that might be a way that they could contact you. Okay, so this is actually pretty easy stuff, you know, this first page here. So it's just filling it out in the name of the person who is the owner of the trademark. And then you click continue. And here's where it gets a little bit trickier, because then now you're making decisions. Okay, are you going to protect your mark as a standard character mark, or are you going to submit a special form drawing in order to protect your mark appearing in a stylized way? So let me do the easy part first. Okay, if you are applying for your mark as a standard character mark, it is so easy. All you have to do is go to this box, type in your trademark. Great, there you go. Nice and easy. All right. All you do is type it in. It doesn't really matter, you know. So this is what it's going to look like on your registration certificate. It happens to be in what, Times New Roman or whatever it happens to be. But it doesn't really matter because you're not claiming exactly what what font it's in. What the important thing is that you're protecting the wording itself. Okay. So that's what you do if you want to register your mark as a standard character mark. Now, let's say the stylization or design element is important to you and you wanted to protect that. So you would click the radio button for a special form mark. And then we see that you have a whole lot more things to fill out. Okay, so in order to do that, you would click choose file. And as you might remember, we looked at some of these earlier. We're going to go with this guy, which is so you would obviously pull it off your hard drive, click attach. And here you go. There's a little mini version of it right here. We'll take a larger look at it later. But we can see here, this is the version we want to protect. It's the stylized version with the mark in color. Okay, so if you were doing that, if you're protecting a stylized version and it's in color, you would need to fill in the literal elements. So what are the words that appear in the mark? And then you would also need to say what colors are in the mark. So here we're talking about orange, blue, and black. So you would type in the colors that appear. You can kind of ignore this unless it gives you a warning. You can ignore this little section here. But then you would come down here to the description, because you also, in addition to saying what colors are in the mark, you have to say where those colors appear and what your mark actually is. So you would type in, let's see, the mark consists of the word T marky, oops, in stylized format, in orange with black and blue outlining, or something along those lines, right? So essentially you're just telling the office, hey, in case you can't tell, this is what my mark is. I'm claiming my mark in this particular thing. It's in orange with black and white outlining, and it's this wording in a stylized format. Okay, so you would fill out that description so the office knows what it is. Now, regardless if it's a standard character mark or if it is a special form mark, you still want to make sure you come down here and check out the additional statement section. Now, these are really pretty rare, and they're probably not going to apply to your application, but they could. And we want to take a look, because TEAS Plus says, hey, guys, you got to front load your application, and there are things that are required. And you'll see the little red asterisk for anything that's required. And then so these are options of things that you can click before you apply. Most of the time, we say don't, oftentimes people just fill out this whole thing, even if they don't know what it is, right? And it really messes up the application. So unless it is actually required that you submit something for it, typically the best thing is to leave the additional statement section alone. But there are a couple things I want to highlight for you. As you can see here, this is one of the asterisks. So if you have an active prior registration, so if you've already registered your mark, T marky, then you can put in the claim ownership by putting in the registration numbers for those other registrations. If your mark is in a foreign language, then you would need to say what is the translation or a transliteration. So let's say it's in traditional Chinese characters or something along those lines. You would have to say how the mark transliterates and then how it translates, and you would need to fill that in as well. Or if, for example, it is the name of an actual person. If your name actually is T. Markey, and then you would say, then you need to fill this in and make sure that you are giving consent for the registration of a trademark, which consists of your name. So those are the sorts of things that pop up in the additional statements section. As I said, most of them pretty rare, probably not going to apply to most situations, but I think it's a good idea to just click on it. Yeah, let me go through there. Jason was talking about it. Let me check it out and make sure that I'm doing everything okay. And so if none of these statements apply to you, then you just uncheck the box and it disappears. Okay, so we're going to go ahead with we're going to go ahead with this one, right? With T. Markey in the stylized form, just so you can kind of see how all this works. You'll click continue, and then you get to the goods and services section. If you remember, I was talking about the ID manual. This is the way that you access the ID manual inside the form. You don't have to. You can access the ID manual before you get in the form, and I'll show you how to do that if we have time. But this is how you do it. And so remember, Jason said, oh, with my trademark, there's always goods and services. Well, here's how I add my goods and services. Okay, so you click add goods and services, and this allows you to search the manual. As you can see here, I've already been playing around with it. So let's say, for example, you are using your trademark as a brand for t-shirts. So you would search for t-shirts, click go, and it's going to show you all the different ways that t-shirts shows up in our ID manual. And you'll want to click the one that is most relevant for you. Okay, so this one up here is the most relevant, really, because it's t-shirts, right? It's a broad sort of thing, but it's also specific. Clothing is too broad. You can't just register your mark for clothing because that could be just about any type of clothing, and we need to know more. But t-shirts is perfectly acceptable. So let's say you click on t-shirts. I will footnote this real quick. International Class 25, I'll talk about that in just a second. But it doesn't really matter for purposes except for the fee that you're going to pay. But I want to point it out because people get hung up on it sometimes, and I don't want you to get confused. Okay, so we're going to click Insert Checked Entries, and we'll check down here, and we see, good, there is t-shirts. All right. But let's say, because I want to show you an example of services, let's see what else. Let's say that you are also doing an online retail store. Okay, and this is kind of strangely returning results, but where's the one I'm looking for? Here we go. Because the cool thing about this one is the online retail store services featuring, this allows you to type in the things that you are selling in your store, which, as you can see here in some of these examples, you have to do, right? So here, essentially, we're saying, oh, you buy groceries, or it's a department store, or it's a convenience store, which we know what those things are, right? So let's say you're doing an online retail store, and you're going to want to insert your check entries, and the system says, whoa, you can't do that. There's a spot you got to fill in. You have to tell us what things are you selling in your store. So let's say it's an online retail store selling t-shirts, and you would type that in. You'd hit Insert Checked Entries. Oh, and somehow it took away our other t-shirts. Let me give me 2 seconds, and I will pull that back up. Okay, great. So they're both up here now. Okay, great. So we now have goods, and we also have services. And the reason I want to show you both is because the specimens that you need are different for goods than they are for services. All right, so let's go, first things first, let's go with t-shirts. Now, remember I said you have to, up here, assign your filing basis. All right, so that's what we're going to do right now, okay? We're going to assign the filing basis. So if you are not yet using your mark in interstate commerce, but have a bona fide intent to do so within the next 3 to 4 years, you would be using Section 1B, intent to use, right? And it's super simple to claim that basis. You click Section 1B, you of course read everything, everybody. You would click the button to say that you agree with all of these things, and you click Assign Filing Basis. Simple as that. And you look over here and you would see, yes, good, the system worked. I have assigned my filing basis of Section 1B for t-shirts. All right, but let's say you are already using your mark in commerce for your online retail store services, which are featuring t-shirts. All right, in which case you would click this in order to assign the basis, and you would click Section 1A because you are using your mark in interstate commerce. And this gives you a way to attach your specimen. Remember, not a medical specimen, but another specimen that shows the USPTO how you are actually using the mark. All right, and the way that you do that is, of course, read everything that's on the screen, and then you come here to attach specimen. And this allows you to go on your hard drive or whatever you want and pull up this image. And remember, it's got to be a JPEG or a PDF. And let's see, I had oh, here we go. Yes, I had saved this previously. So we're gonna show you a website example for a specimen for online retail store. So let's see, we've got the file here. We would click attach, and you can see it's been uploaded. Great. And then you can return to the form. And I'll show you exactly what these specimens are, okay? But I just want to very quickly show you how you fill this out. So you have one file attached as your specimen here. You are going to say what the specimen is. So in this case, it is a website screenshot. And you have to, if it is a website screenshot, you have to do two things. You have to include the URL. In this case, it's tmarkey.com and the day that you accessed or printed or downloaded or screenshotted the thing. So whatever today is, let's see, I think it's the 11th. Okay, and you will also need to include the date that you first started using it anyway. So it could be in Missouri, it could be wherever it happens to be, right? Wherever you are, the date that you first started using it anywhere, let's say that was on July 1st of this year. And what is the day that you first started using it in interstate commerce? Well, for the most part, if we're talking about things that are taking place online, it's usually the same date. And it could be the same date in all cases. So whatever date you first started using it across interstate line, or across state lines or country lines, then you would fill that in. Oftentimes this date is the same, okay? So don't get too thrown off by it. One means when did you first start using it anywhere, and then one is when did you start using it across state lines. So that's sort of the difference. And you would assign that filing basis and double check it. And you can see, oh, good, we've correctly assigned this filing basis. All right, so that's all set. Now, before we move on, we're just about done. I do want to very quickly show you sort of the differences in terms of specimens for goods versus specimens for services. So the way that it sort of works is for goods, for the specimen that you include, it needs to show we need to see the mark on the goods themselves, on the packaging for the goods, or say a label or a hang tag for the goods. All right, so let's say you have t-shirts, you would need to show a specimen that shows the mark appearing on the, in this case, hang tag for the t-shirts. Or, oh, that's the good one. Or it could be on a label for the t-shirts. Now, I'll very briefly ask you, so what we put in our application was tmarkey in orange. All right, so let's say we applied to register tmarkey in orange and we submitted this as our specimen. Does this match exactly what we included as our drawing? No, it does not. So the examining attorney would refuse your application because of this specimen, because as you can see here, tmarkey does not appear in orange, it appears in black and white, right? Or just black or gray or something along those lines. So how could we avoid this situation in the future if this was the specimen that we knew we needed to include? Well, we could apply for our trademark in black and white if we needed to protect it in the stylized version, and that would match up okay. Or we could apply to register tmarkey in standard character format, because at that point, we don't care what it looks like on the specimen, right? We don't care that it's in black or white or orange or blue or whatever it happens to be. It can be in any style, shape, color, things like that, okay? So we're talking about, in terms of specimens, we're talking about a hang tag, we're talking about a label. It could be, for shirts anyway, it could be the trademark appearing in a traditional trademark location on the shirts. So here it's in the left breast pocket area. It's a traditional place for trademarks called neat and discreet, right? So that could work as well. So that's what we're talking about for specimens for goods. I've included this one here because this is like the prime example of what are all the great ways you could use a trademark and have it appear on your goods for your specimen. So we see a hang tag, we see a label, and also in a typical situation. So let me show you very quickly what we're submitting here for our website specimen for our services. So we see here, can't see it very well, but trust me, it's there. We see the URL, www.tmarky.com. We see our trademark, tmarky. Okay, good. And we have an online retail store for selling t-shirts. And we see, oh, look, yes, we are selling t-shirts. Okay, so this sort of specimen, this screenshot, could work as a great example to support online retail store services, in this case, for t-shirts. Now, of course, obviously, this is a mock-up. This is not a real website. In your case, it has to be real, okay? We do not accept, mock-up specimens or digitally altered. We don't accept something that you photoshopped. It's got to be a real thing, okay? So this is just to show you examples, all right? Now, here's the other interesting thing before we quickly move on. This particular specimen could also work as a specimen for goods. Now, remember how I said they're kind of different things. For goods, it's got to be on the goods themselves. For services, it just has to be showing, we see the mark in the advertising or rendering of the services. The cool thing is something like this can work for goods, and here's why. It is considered an electronic point of sale, all right? An electronic point of sale display. And the way that works is three things, okay? We see the trademark right here. We see the trademark being used in relation to the goods. So it could be a picture or a textual description of the goods. So we see that here. And we also have here what's known as an inducement to sale. So that buy button, the add to cart, all the purchase, whatever it happens to be, any of those sorts of buttons, that can work. So what we have to have is all three though, right? You have to have the mark used in relation with the goods and a way for the consumer to immediately purchase the goods. And if you have all three of those things, well, that could also work as a specimen for goods. All right, so that's kind of like a little side note, just a little cool way for you guys to think about what your specimen could be. Okay, so we're going to jump back into the form. We've already assigned our filing bases. We've attached everything that we need to. So we're going to hit continue to move on to the next section, and we're just about done with the form. All right, so here we're just double checking. Yep, that's my name. Okay, and this is my address here. You have the option here to add some additional email addresses for courtesy copies. It could be your business partner, or maybe you, in addition to your business email address, you have your personal one, and you want to make sure you're getting it everywhere. So you can put in additional email addresses there. Now, here is where we get to the money part. This is where people sometimes get a little, confused and want to make sure they're doing things properly. So if you remember, we filed we're going to register our trademark for a couple of things for those t-shirts and also for the online retail store services featuring those t-shirts. And those are called, those are in two different international classes because all goods and services are divided up into 45 different categories of goods or services. And they're called international classes, not because it's an international application, but because of our agreements with countries around the world. Everything is sort of like governed by treaty. So in this case, clothing is considered a class 25 good, online retail store services are a class 35 good service. And for the most part, the class doesn't really matter. Don't get hung up on it. The only reason that class really matters for your purposes is because it affects your price, all right? Your filing fee. Because your filing fee is calculated based upon the number of international classes in your application. So in this case, because we're claiming goods in 25 and services in 35, then that's 2 classes. So that's the filing fee times 2. Now, just to let you know, what if you're like, okay, Jason, fine. What if I have hats and I have t-shirts and jackets and shoes? Is that 4 different international classes? No, it is not, because all 4 of those types of articles of clothing are all in International Class 25. So if you wanted to, you could have 5 or 10 or 15 different goods in one international class that you're using your mark on, totally fine. And you're only paying that one filing fee for that one international class. I will say, however, please do not try and select everything in an international class. Do not do it. You're never going to use your mark on all those goods or all those services. So please be very specific when using the ID manual. Only select those goods and services upon which you're actually using your mark or have a bona fide intent to use your mark. Okay, so here we have 2 filing fees. So $250, which is the cheap price, times 2 is $500. Great, good, good, good. We're going to come here to the signature information. The radio button for sign directly is automatically selected, which is great because this is the easiest way to do things because there's not a whole lot you got to do. You're going to come down here, you're going to read everything, and you're going to click on all the check boxes, signifying that you've read everything. You're going to put your name in here. So here, so this is an electronic signature for our purposes. So it's / your name / and the date, which the system already puts in there. Signatory name is John Doe. Signatory position is owner. And phone number, we'll just do. And then click validate. Okay, this gets you to the validation page, and you can go through and look and see, did I put everything in correctly? If you click input, you can kind of scroll through. Oh yeah, that's right. I did T marking. Orange, blue, black. Good, 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 good. Description. Yep, that's correct. Yep, that's me. That's where I live. Individual. Okay, all right. That's my goods. That's the services. Excellent. Good, good. Oh, okay. So everything here is fine. Great. You can just double check all that stuff. You can also check your mark. Yep, that's what I put in there. That's exactly what I want it to be. You can check your specimen, and you can look, did I upload the correct one? Yes, good, I did. Excellent. And we see the mark. Okay, perfect. So that's all set. And then you can scroll down to step 2. Yep, that's my email. I didn't put anything else in there. Here's step 3. It's weird, and I think they're working on changing this, but this is the only time you can save your form. Okay, unlike more modern forms, perhaps, where you can save it throughout. That's not the case here. You only kind of get one chance to save it, and that's at the very end. And if you do want to save your form, you can come down here to the bottom, click Save Form, and I think it saves it as an XML file, which you can then reopen later on. But it's an option. You don't have to do it because you're almost done, so you probably don't have a whole lot of reason to save it, but maybe you do. Then you go through step 4, you read all that information, you click there, and now it's time for you to pay. And you would come over here to pay submit. And this brings you to the sort of like the finance manager, right? And so this is your way that you input your credit card information in order to actually pay for it. And this is what it looks like. So obviously I'm not going to put it in here. So this is about as far as we're going to go in the form. But once you fill in your information, you click submit payment and everything's good. You'll get to a success screen and it'll give you your 8-digit application serial number and say, congratulations, you filed your trademark application, and a whole bunch of other information. And that's the form. And that is pretty much it for that. And I am obviously open to taking all questions. So I'm actually going to, at this point, I'm going to stop sharing, and Sherry, you can come back on perhaps, and we can maybe go through some questions that people might have had. And I can also show various things on the website or whatever it happens to be if people have questions they want to see. What in the world was he talking about? He talks way too fast.
Are you able to hear me? I have 2 videos.
Yes.
Okay, there you go. It came up finally. Jason, that was fantastic. I mean, where have you been? I can only imagine. And Joan is on here, Joan Brennan, and I had to talk her into filing her own for her own trademark because she thought it was so complicated. And she's been an inventor for over 20 years, right, Joan? She's on the She's on the board of the Inventors Association. And I can't emphasize enough how necessary this information is. And this is what I have been trying to convey to everyone. Inventing doesn't have to be so hard. And not just inventing, but business startup. But one of the things, there are a couple of things that I'd like for you to address, and I'm going to turn it over to the audience to pose their own individual questions. But we need to let them know that when you fill out the form, that your information becomes public to the world. And it also lends itself to a lot of solicitations, instant solicitations. I mean, your submission may not be 24 hours old and you'll receive things. So you have to be very selective about what address and email address that you provide, because you're thinking that as an inventor, you're thinking that you're submitting just to the USPTO entity. And so you're comfortable with the government entity having your information. But the truth of the matter is you're going to have attorneys and different service providers that's going to reach out to you. So I think you guys need to know that. And then
I can show you as well. Let me share again real quick. I'll show you what we have on our website, because trust me, folks, this has been a problem. And the reason that it can that folks can do this is because under the law, all the information has to be made public, and that is because people need to be able to find trademark owners. So we have created here under trademarks this caution misleading offers and notices page. And you can see here, we sort of explain more about it, talk about all these potentially misleading offers you might get. Look, I was doing a presentation one time in Hawaii, and before I began, some guy came in and he's like, "Oh, Jason, thank goodness that you're here. I want you to take a look at this real quick." He's like, "Did this come from you? Because it says I owe like 4,000 euros or like 100 or $1,000, whatever. I forget exactly what the specific number was." And I looked at it and I was like, "No, man, this didn't come from us." And he's like, "Oh, Jason, thank you so much. You just saved me. Like, I didn't have $1,000, 4,000 euros or whatever it was to send to these folks. And it was a scam. Somebody was trying to get him to pay for something he didn't need to." And so it's very important that Sherry, I'm so glad you brought that up. So you can go to this webpage. We got a little video. You can see Mark Traven, Trademark Information Network, talk to you about solicitations. And down here at the bottom, we have a complete list. We've uploaded essentially examples of all the stuff that we've seen over the years. And if you pull some of these up, we'll just pull up the first one here. Somebody is calling themselves the Patent and Trademark Office, right? So it sounds like us without the United States at the beginning. And this is what they're sending to people. This, Washington, D.C., pending trademark cancellation. It's about to expire, right? All this sort of stuff. Look at this renewal fee of $1,650 and $850. None of that is true. You know what I mean? So there's all this sort of stuff that's out there. So please be aware. And what I would say is the quickest and easiest thing you can do to avoid these solicitations and avoid freaking out about it. Yes, you're going to get them. But once you get your application, go to TSDR, and I don't know, I'm just going to make up a number here. You can look in our system and you can see every single thing that is in your file. All right. So you can go and you can look at the documents that are in your case, and you can look through everything here, through all of these things. And if you don't see something that looks like what you got in the mail that says that you owe $10,000 or we're going to come to your house and drag you off and put you into jail, then we didn't send it. Okay. You can ignore that thing and move on. All right. So thank you, Sherry, for bringing that up. That's an incredibly important point. And I know.
Yeah. And they also need to be careful about their phone numbers, because now you'll get blind texts from individuals that are soliciting as well, and it can tie up your business line. So I guess as a rule of thumb, you want to set up different accounts. If you have a different office address and you're debating whether or not it's more convenient to come to your home versus your office, then perhaps provide an office address. And then if it's in the budget, to set up your own separate phone line strictly for your business, or maybe a dummy line, if you will, that'll be separate. And you'll know that it's at risk of solicitation, then do that, but you don't want it to be your main line. Other than that, if you have a problem, who do they call? Because you guys have excellent service as well, as far as if you run into a glitch or you misinterpret the information, the wonderful information that you provided, there's help still available.
Yeah. So there are two things. Once you apply, your main point of contact is going to be the examining attorney who is assigned to your case. And so that person is going to know everything about your case, and you can email them, you can call them, and you can say, hey, I don't understand such and such. And we're all incredibly nice people at the office, and everyone's busy, yes, so we're probably not going to be able to chat forever. Although I have to say, I had one guy who used to call me all the time and be like, yeah, now, Jason, what are you up to? And I'm like, well, I'm kind of working, but, there are people who just kind of want to chat, and that's okay. But the examining attorneys are really great. And so that's going to be a great source of information. The other folks you might want to contact are the Trademark Assistance Center. And you can, I think they're available like 8:30 a.m. to 8 p.m. East Coast time. You can email them and questions and things like that. And they are really great. Customer service is their number one priority. They want to talk to you. They want to help you. They want to guide you to places on the website and send you links and things like that. So there are sources at the USPTO that can help you.
And then, of course, you guys have videos on YouTube. In addition to sessions like this, even though we brought you here, you also have other sessions as well. Do you have any that are coming up that's a continuation?
Yes.
Okay.
Yes, we do. We are just getting ready to release it. It's kind of official. Maybe it's not official. Maybe you guys are the first ones really kind of hearing about it. But we are going to be doing an 8 weeks Trademark Basics boot camp, which is going to take you through the process, application to registration process. What you heard today is like, I think week 4 in that. So there are 3 weeks before that where we go through basics and searching and application requirements, and also what happens after you file, responding to that office action, what happens once your mark registers, and what are the forms that you need to file to keep your registration alive. That's going to be there. And also at the very end, final week is going to be sort of a Q&A section hosted by the Trademark Assistance Center with various experts in the office, and you'll be able to write in questions or ask questions, and they will answer them as best they can without giving legal advice.
And Mike, did you have anyone in the chat that had questions?
We do not have any questions in chat yet, but everybody's welcome to be able to post and share your questions with Jason or Sherry.
Jason, what are some of the common mistakes that are made with pro se applicants that they want to make sure that they don't overlook?
Well, that's a great question. And a lot of them are the things that we went over today that are actually on the pre-filing checklist. Okay, so one of the big things is actually identifications of goods and services. It is incredibly important that you do select the right ID. Because if you select the wrong ID, you are never going to be able to register your mark because you're not actually using your mark for whatever goods or services it was that you identified. So you have to be very careful about that, all right? And one of the things is to think about what are the actual things that you're using? What are the actual products or what are the actual services? You're not going to put down how you're using it. You're going to put down what are the things that have your brand name on them. And one of the prime examples, and it was a famous case, is that there was a winemaker who had applied for their trademark and they put down for their goods wine labels. Well, they don't make wine labels, they make wine. So they were never able to submit evidence that they were using their mark for, whatever branded wine labels. So they needed to reapply for their trademark for wine. All right. So that's the big thing. It's like, well, I put it on business cards. Should I put down business cards? No, not unless you're a person who prints business cards. And then in that case, maybe. But it's incredibly important that you figure out the right identification of goods and services. So spending time in the ID manual is incredibly important. It's the other reason that we do, even though it's not required in the United States to have an attorney represent you, we do recommend it because an experienced trademark attorney is going to be able to help you look through the ID manual and say, okay, you got this brand new technology that you're inventing. It could be this, it could be this. And then they kind of like go through the manual and help you figure out what it is. Because even if it's a brand new thing that you've come up with, you can have like a broader name for the thing, for the goods themselves in the ID, like, you know, and you can probably use that because you don't have to make it like a patent claim where you're like in descending order of, you know, specificity or whatever it is. So that's really important. A lot of other stuff is often fixable. Like if you submit a specimen that doesn't exactly work, the examining attorney will tell you and say, hey, this doesn't work. You know, this is what's wrong with it. And you can say, oh, okay, no problem. Here you go. Here are some other examples of how I'm using my mark in interstate commerce. And the examining attorney will say, yay, awesome, great job, cool, that works. And we can approve your application and get it moving. So
common projections that they should know about as far as their name. You can't use your surname, and also common words. Say, let's give them the example of lovely. So if you look online and there are different variations of the term lovely, but you decide no one's done the word lovely by itself, explain to them why they can't use that.
Well, you know, here's what I'll say. I'll push back a little bit on that. I'll say there's a possibility they could register lovely, depending on what it's for, because one of the things you have to think about, and if you,
that's true, depending on what it's for.
If you're able to attend the boot camp, you'll hear more about this because we can
for
get
computers. Then okay.
Yeah, we can get more in depth on this sort of stuff.
Okay.
But because there are two big things, there are two major reasons your mark could be refused. One is likelihood of confusion, which is that somebody else is using the same or similar mark for related goods and services. And the other is what Sherry's talking about, is what's known as descriptiveness. So if your mark is merely descriptive of the thing that it's used with, then your mark will be refused because it's not really functioning as a trademark, right? It's not indicating source, it's just telling you what the thing is. So
you can't use the term rose. To give you an example, guys, you can't use the term rose. You can't trademark rose to sell roses. But if you're wanting it to for computer sales, then and it's not taken, then that's a possibility. Is that correct?
Right. That's right. And those are what are known as arbitrary marks. So the best marks are what are known as fanciful and arbitrary marks. So think about Apple, right? If you're selling apples, Apple is no good, right? Because it tells you exactly what the thing is. Apple for computers, yeah, no problem, right? So that's okay. So those are known as arbitrary marks. Fanciful marks are made up words like Exxon or Kodak, Xerox, things like that. Those are just like made up. I don't even know what that is, right? So those are both what are known as very strong, inherently distinctive types of marks, and those are great. Those are great. And
Jason, last names. What are some of the challenges with last names?
Oh yeah, with last names, technically, if something is primarily merely a surname, it is going to be refused at our office. However, if it's not primarily merely a surname, if there's additional elements that are there, then it is something that could be registered. So if your last name was Penny and you had a clothing department store, well, actually, that's a terrible example. Sears, your name was Sears, and you had a department store, that on its own, probably not. Maybe that's not a good example either. How about...
well, they were saying that certain law firms couldn't, which was ironic because a lot of law firms use the last names of individuals.
So if it's more than one surname, sure. Like Johnson & Johnson, that's registrable. If it's J.C. Penney, that's registrable. Okay, Montgomery Ward, that would be registrable, right? Because it's not primarily merely a surname. There's more to it than that. Or if it is a surname that is like, I don't know if it's, my last name is Lot. If it was, Lot Donuts or something like that, and that's a terrible example. Lot, I don't know. I can't come up with a good example off the top of my head. But if it was like, combined with something else that, like a more suggestive or fanciful or arbitrary, then in that case you can. But if it's just the surname alone, then it is going to get a refusal.
And Jason, I'd love to be able to open it up to our audience. Fanta is one of the students here at WashU that has been very involved with our different competitions, and she had a question. Fanta, would you like to go ahead and ask your question for Jason and Sherry?
Sure, thank you, Mike. Hi, Jason. Thank you so much for doing this presentation. I actually was looking at trademarks for a while, and I have a skincare business, so I go on and I look at my competitors and see what they're doing. And a question that I had was, with my products, they have various names that are very unique to them. And I was wondering, when doing a trademark, like if I was to trademark the business name, can I include those products names? Or like, let's say like the t-shirt example, if each and one of those t-shirts had their own names or like slogans written on them, would that require an additional trademark for each of those slogans?
Yes, if you wanted to protect each individual name of the whatever particular, so you have your overall brand name, right, for your skincare stuff and for your makeup and cosmetics. You can register that. And then if, let's say this one particular lipstick has a particular name and you wanted to register that as the brand name for that thing, that would be another application. If another thing for a concealer, another thing for the whatever, I don't know, all the makeup, like another for a lotion. Yes, you would have different applications for each of those. You're not necessarily going to combine them all into one because every application is for one particular trademark. So if you're registering your overall brand, then that could be one, and then one for each individual type of thing. Or if you have a line, it was like, this is my blank line of lipstick. Sure, that's fine. You could do that. You could register that as for the line of lipsticks or compacts or whatever it happened to be. Does that make sense?
Yeah, it makes sense. So let's say, for an example, I have 4 butters. One is called Coconilla, the other one is called Aloe Euphoria, and let's say the other one is called Blooms. Each and every one of those would require doing a trademark for, right?
The only thing I would say is nothing is required, okay? Because it is up to you if you want to register it, right? So you could go your entire lifetime and your entire business lifetime and never register those trademarks. You could rely on what is known as common law trademark rights. If you want federal protection, though, yes, you would need to register it like each one of those individually in order to protect them.
Okay, cool. And then just one last question.
Yeah.
So if I had, okay, like my native tongue, if I have a word, let's say like a man, right? And I wanted to trademark that word because it's not necessarily used here in the United States. Is that something that I can do? Or if it's like a generic word, I cannot really use it, even if it's in another language?
That is a fantastic question. Thank you for asking that. If a word has a meaning in another language that is spoken by an appreciable number of people in the United States that might be, that potentially would be translating it, then you would not be able to register it, especially if it's a generic word in that language.
Okay.
Right. So if it was, salsa is a bad example, but let's say I want to register salsa for my salsa, right? You know what I mean? So people know what salsa is, right? So you wouldn't be able to do it, right? So if whatever word it is generic for whatever skincare product in that language, and that language is likely to be translated by folks in the United States, and I can't give you a bright line rule for if it's over 100,000 people, then it's no good. But if it's under, because it doesn't really work that way. It's going to be fact-based, and the examining attorney assigned to your case is going to do research. Like, what is this language? How many people in the United States speak it? You know what I mean? So they're going to start to do that sort of analysis. For things like dead languages or a language that not very many people speak, then oftentimes you can, because it's not going to be translated by most Americans. But if it is something, certainly French and Spanish and Italian, maybe German, other sorts of things, those are going to be translated. So those are probably most likely to be refused. But if it's a language that isn't spoken by a whole lot, then maybe it might be fine. But maybe not. But the other thing to think about, and again, not legal advice, okay? Not legal advice. However, one thing to think about is think about your company and it expanding over the years, right? Are you going to want to expand your company back into that country, right? You know what I mean? Like, so if you're thinking ahead, like, how is it going to be translated in other countries? Is it going to be found generic there? Then I won't be able to protect it in whatever countries it is that I want to move into. So that's why it's so important right now to be thinking of, and I love that you asked that question, is like thinking about those rights and start to think internationally for how am I going to be able to protect this around the world?
Got it. All right, thank you so much.
Yeah, you got it. Good luck with everything.
I know. That said, that's going to have to be our last question. We have to get prepared for the next session, which I hope everyone is planning to stay for. But I want to take this time to say, Jason, that was fantastic. And we most definitely have to have you back. And I know Mike at the Scandalera Center is more than happy to have you come back and go through this whole orientation or introduction to trademarking, most definitely. So thank you so much. And you did this at the last minute too. So I just want everyone to appreciate that. How you guys showed out and showed up. And we, I mean, can't find the words to express how much we appreciate you. So thank you for that. And for the rest of you guys who have participated, thank you for showing up, and stick around for the next session. We'll go ahead and take a 5-minute break and afford James an opportunity to set up his slides.
Jason, thank you so much. This is a topic that our community, our students have really been asking for. Tremendous. So we love your passion and your presentation. Thank you so much.
Excellent.
Awesome. Thanks for having me, guys. I appreciate it. Well, I'm sure I'll see you all soon.
Jason, I'll be in touch.
Okay, sounds good.
All right.
You got it. Enjoy James.
I know.